So, good morning, Mr. Thomas P. Valenti, and good evening, Professor Anand Shankar Singh, Principal, Iswar Saran PG College, Mr. Gauri Gulati, Founder and Managing Director, Droit Penale Group, a unit of Arjun Gulati Memorial Society. For the fifth session today, we have Mr. Thomas P. Valenti. Mr. Valenti is a Chicago-based conflict resolution specialist offering mediation, arbitration, and facilitation services and training globally. A certified mediator, Mr. Valenti has conducted numerous mediation involving civil, commercial, interpersonal, and workplace matters. He has mediated and trained extensively both nationally and internationally in jurisdictions all over the world. Mr. Valenti is a member of several bar associations, including the American, Chicago, Illinois, and Indian Bar, and is a co-founder and former board member of Mediation Beyond Borders. With a passion for mediation, highlighted by many qualifications Mr. Valenti holds in the field, Mr. Valenti is a dedicated and talented mediator. A member of the Chartered Institute of Arbitrators, Mr. Valenti is also an arbitrator on the public panel of FINRA and is an approved arbitrator and mediator for several governmental and regulatory bodies, including the Circuit Court of Cook County. The National Arbitration Forum is on the advisory board for the Association of Mediation Assessors, Trainers, and Instructors. Mr. Valenti also holds a mediation certification at the Institute of Conflict Management and is a board member and trainer at the International Academy of Dispute Resolution. Training others to mediate is central to Mr. Valenti's belief that alternative dispute resolution is a powerful force for good. Working with the International Academy of Dispute Resolution, INADR, a charitable organization created to develop an understanding for the benefits of mediation amongst law students, Mr. Valenti has traveled to UK, Dubai, India, and Europe to deliver mediation training for students. He is also an International Mediation Institute's mentor to youth. We are really honored to have you with us, sir. Now, I would request, sir, to proceed with the lecture. The topic for today is Methods of Training Alternate Dispute Resolution ADR.
Thank you for the kind introduction. And thank you all for joining today. I hope we can have an interactive session. I have some lecture to talk about, but for me, I'm very happy that I'd be interrupted by questions. It's a little bit challenging for me to watch the chat at the same time as I'm giving the lecture. So if there's someone who wants to monitor the chat room, one of the leaders there, feel free to interrupt me with questions as we go along, because it might be more meaningful for me to answer them during the course of my lecture rather than at the end.
Yes, sir. Sure, sir. I will read out the questions if there are any, and I'll interrupt you in between. Yes, sir.
Anytime you wish, because it's easier for me that way, and I think we'll have a more active session because I prefer that.
Sure,
and the session hopefully will meet your expectations, and so let's go. I have some slides to start. Our topic today is ADR, or Alternative Dispute Resolution in the COVID era, and I saw in the chat before we started some people have some questions about ADR itself, and then how we might be managing that in this time. I can see from those of you who are showing me your video, if there's a beauty or some benefit to COVID is we're all the same. I'm calling you from Chicago. It's 6:30 a.m. here. I'm in the lower level of my home. You're probably all trapped as well. And so we can be whoever we are, but this mechanism of that COVID has done to us has kind of equalized all of us. So we're all the same today. Let me start the presentation and make sure you're seeing it. Are you seeing just one slide? All right, so are you seeing the slide now?
Yes, sir.
All right, great, thank you. So here's what I hope to do with you today. Is we're going to cover a general introduction of ADR, or alternative dispute resolution, talk about the impact of COVID-19 on dispute resolution generally, where we might fit into that picture. And what I mean by that is how lawyers, professionals, maybe students working in law offices and internships, or how we might imagine our future if we were a student, how we might fit into the future in the time of change that we're in. I'll give you some examples of how we are using online mechanisms to approach dispute resolution now. And we'll talk a bit about addressing the concerns that people have about using technology to do things that we normally did face-to-face. And so that's our agenda for today and our goals for today. So to start, when we use the term ADR, alternative dispute resolution, we talk about a variety of methods of resolving disputes instead of litigation. The alternative was always, what do we do instead of take a dispute to court? And that became a popular thing in the US in the 1970s. It has become more popular over time in other countries. I've been doing work in India for almost 10 years now, and the uptake is a little bit slower there, and has always been slower for a variety of reasons, which we can talk about later in the Q&A if we want. The theory was that these other mechanisms avoid some of the acrimony or the fighting that can go on in litigation, can avoid extended and costly trials, and allow people to participate more in making their own solutions. The most common forms that we think of when we talk about alternatives to litigation is negotiation itself, something called facilitation. You have in your act something called conciliation. Then of course we have mediation and arbitration. And I always like to mention community dispute resolution programs as well, because that's something that I'm interested in. And I'll tell you a bit more about that shortly. So let's look at each one of these. Negotiation is quite simple. It's just a strategic discussion involving usually two parties. Sometimes it's parties and their lawyers. And we usually try to persuade or get the other side to agree with our point of view. The goal always is to reach a compromise. In many jurisdictions, there's very formal courses. Many schools around the world offer dedicated courses in negotiation itself. Perhaps the most famous negotiation model is based on Harvard University School of Law and its other institutions. That is based on the theory of interest-based negotiation. The program on negotiation at Harvard has a model that's followed by people all over the world now, and that's a very common way of looking at negotiation. Facilitation is a bit different. It involves a very informal way of working with people to reach a settlement, or sometimes not always a settlement, but just an understanding of a problem. A neutral third party, like one of you or I, is hired by somebody, and sometimes we do this with corporate boards, where there's more than two people, sometimes 10, 15, 20 people involved, and often they need a guide to manage the conversation, to make sure that there's enough time for everyone to be heard, and that everyone's viewpoint gets made. And we call that facilitation. It can be done in person at a board meeting. It can be done with university faculty. It can be done in a variety of different settings. And what we're doing is trying to give people a full understanding of a dispute. Maybe they don't always agree, but they agree to listen and understand each other. Mediation is a bit more formal than facilitation, but still leaves the control of a solution. Mediation is very solution-based, and in mediation, usually we're talking about a solution being some settlement. An impartial mediator helps the people reach acceptable solutions. Many times where mediation is new, people believe that the mediator himself or herself makes the decision, and that's not what happens at all. The mediator is much like a guide or a GPS system where we get people to think about solutions, but we don't suggest or decide. We usually start our sessions listening and getting people to think about what the conflict is, help explain the conflict, and help tell their story in a way that lets the other side learn what their real interests are. Once we identify the interests of each side, we can help them think about a solution that meets the interests of both parties. And that's the fundamental premise of this Harvard model of negotiation, which is what we call win-win, where each party feels at the conclusion of our mediation that they've taken something that has some benefit for them. Conciliation started in India with your 1996 Arbitration and Conciliation Act, and it's really something that has come to be known as a mediated solution is the result of the court system making a referral. The advantage to a conciliation in India is that because it's attached or annexed to the court system, that the mediation solution can become a judgment of the court. That's something that has always bothered people in many jurisdictions where a mediated solution or a mediation settlement agreement doesn't have an enforceable fact behind it. You would often, in many jurisdictions, have to file another piece of litigation to enforce the mediation settlement agreement. In India, that has always been something on the mind of practitioners. In many other jurisdictions, they don't worry about that. They don't worry about it because in mediation, the compliance rate, and by that I mean when we reach a solution in mediation, 99.9% of the time, the people perform the agreement. And why do they do that? It's because no one told them to do it. They reached their own solution. And so that's hard for people to understand until they start working in mediation and realize that the parties are happy to comply because they came up with the solution and wasn't imposed upon them. The role of a conciliator in India is to assist the parties. Usually the conciliator could be a sitting or former judge, and they're guided by the same principles that mediators are. They're objective, they're fair. They try to give consideration to the rights and duties of the parties. They conduct the proceeding in a manner that's suitable to them, but also takes the interests of the parties in mind. Probably the most formal method of alternative dispute resolution is arbitration. In many jurisdictions, people refer to arbitration as rent a judge, because we as arbitrators are empowered by the contract or the agreement of the parties to make the decision about the case, much like a judge is empowered by the Constitution or the legal system in different countries to decide matters. In most jurisdictions, the decision of the arbitrator or tribunal, and when we say tribunal, often arbitration panels consist of 3 people, appointed either by the parties or by some system. There's very little opportunity to appeal the decisions of arbitrators. In courts, that's not always true. There's usually some form of appeal or redress from the decision of a court. Arbitration was designed to eliminate the length and cost of proceedings to make a quick and effective way of resolving a dispute. And so the review process, the ability to appeal, is often quite limited. And in most jurisdictions, it's left to some kind of improper methodology by the panel. They didn't provide a full hearing, or perhaps there were improper disclosures by the tribunal, and they had some pre-existing relationship with one of the parties that was not disclosed, and that may have led to a fraudulent decision. Let's talk just quickly about community disputes and as a method of ADR, of dispute resolution. We see in times that a community dispute can be something as simple as, in some countries, neighbors fighting with each other about the behavior of animals, or perhaps encroachment of property lines by nature, by trees and things like that. It can mean, in some jurisdictions, disputes between groups of people. And in this era, in the most modern times, in the year 2020, for example, we've seen disputes in communities that involve movements of people. And that can be, for example, in India, citizenship issues, in the US, police violence, or the Black Lives Matter movements. And we, as conflict resolution professionals, can be engaged to facilitate those disputes. If you see the picture in the upper left here, and I can't really tell if it's a gentleman or a woman who's probably facilitating a conversation amongst community disputes in that jurisdiction. We've seen a call in recent times for the use of mediators to be involved in these kind of public disputes, where often those conversations can be quite active, maybe loud and noisy, and perhaps a bit angry. And governments and community groups have found that having neutral third parties lead that, rather than a member of the government, because often the government is perceived as being the other side. And so governments are hiring people like you or I to help them with those kinds of disputes. Now we move on, unless there's any questions so far, we'll move on to, after that background information on ADR, we'll move into our discussion of COVID-19. I'll pause for a moment to see if there's any questions.
Yes, so there's a question.
Sure. I'm going to stop sharing so I can, we'll go this way and then I'll start again. So the question is, go ahead. Yeah.
The question is, in community dispute, how decision is finalized?
Good, very good question. So usually in community dispute resolution, there's different methods. So if let's say it's the simple one, it's you and your neighbor having a dispute about a property line, or maybe the way you manage your pets and things like that, we can often reach an agreement between those homeowners that's formalized in a settlement agreement and some kind of handshake and or maybe even a document itself. When we're talking about the larger community disputes like, let's take, because it's quite popular now, the police violence issue in many cities in the US and maybe even around the world. We don't look at a solution. We look at helping them craft maybe a piece of legislation. And so we might take information from community members who have been harmed by the police, community members who feel that there's more need for police, and we share the concerns of each stakeholder. And by stakeholder, we mean all those different people who are interested or have some interest in the problem. And even, for example, in Chicago, where we have violence issues here, there are people who say, we don't want police anymore. We want to do this ourselves. And there are people who say, no, in my community, we need the police. And so we hear from each of them, and we give the governmental body who has the authority to impose rules upon police forces, we give them the input that comes from the community groups. and then help them fashion a legislation or a change in policy that includes the interests of all parties. And we hope that by the end of these discussions, and often it's not one discussion, it may be a series of mini discussions where we take agenda items one by one and get input. It can take a long time. It can take months with dozens of meetings where each topic is discussed one by one and a policy provision is recommended to the governmental agency or to the lawmakers themselves about how to proceed. It's ultimately up to them to pass a law, but when we're dealing with community issues, the people feel more inclined to comply with laws that they participated in drafting. And that's the goal of community dispute facilitation. Any other question?
Hello.
Yes.
Sir, I had a question. Sir, regarding this community issue, so indirectly we can say that in community issue, there is a need of new legislation whenever a new issue arises in the society?
Well, some people believe that there needs to be changes in laws as a result of changes in things that happen. I'll give you the best example is you probably are aware of the George Floyd death in Minnesota here.
Yes, sir. Yes, sir.
Yeah, and that was the result of a particular tactic that the police were trained to do. This kind of chokehold with the knee on the neck. And once that became known, we learned around the country, and it's available to police in other jurisdictions as well, that that was what policemen were told to do. And now very quickly we're banning the use of the knee hold and even chokeholds themselves by police. And so that was without the result of any formal community facilitation dispute dialogue, but really the result of protest movements and things like that. And so the community disputes can produce change quite rapidly when the examples are that obvious. And when there's video evidence of things where the result is not at all what was intended by the government, police force, or the community themselves. So we don't always need a law. Sometimes it's just a policy change within that agency. And here, for example, a police department policy change can be invoked by the mayor or the head of the government without a change in the law. Sometimes it takes a change in the law.
Thank you, sir. This was something, a really new thing which I learned from you, sir.
Thank you.
Good evening, sir. I have a question. When we are talking about the mediators, so any person can be a mediator. For example, there's a dispute between two persons and one says, okay, my brother will be a mediator for resolving this dispute. So any person can be a mediator?
Yeah, that's a complicated question, but I'm gonna give you the best answer I can. So in different countries, well, I'll take you, for example, the best example I can give you is here. If you came to Chicago today, you can say, and I think your name is Mamta, you can say, I'm Mamta Sharma, I'm a mediator, and you don't need any training, any qualification, nothing. You can just come here in my jurisdiction and say, I'm a mediator. Okay. You won't be able to get any cases from the court system because you didn't participate in the training that the court system approves. But if you advertise for it and say you do it, if somebody found you through your website or from social media or something like that, anybody can hire you to be a mediator.
Okay.
In other states, in other countries, in other nations, there's a qualification process where training is required. The training is valuable. And in many jurisdictions, you're not allowed to be a mediator unless you have taken a training and someone has said that I was your instructor and I observed you and I passed you as a mediator.
Okay, thank you, sir.
And that changes around the country. In India, I think there's still qualifications for that, and actually you can't qualify without, I think, still 7 years of legal practice in order to be involved in one of the court annexed mediation systems that are in place. And now we're seeing many institutes in India. I've done mediation trainings in India. Now there's many people doing it because they see this uptake in mediation.
Okay, thank you so much, sir.
Any other
Good
questions?
morning. Sir, I have a question. It is in continuation of the community dispute. As you said, sometimes we can change the policy, and by changing the policy, the mediator can solve the dispute. But my question is, can mediator play more active role? So let's say if the government is not ready to change the policy also and not addressing the issue properly, can they play more active role in that for getting the dispute solved?
No. No, in general, and I'll emphasize this because I didn't before, is that one of the hallmarks, or one of the best or the highest values attributed to a mediator, is what we call neutrality. And so a mediator, and this relates to Mamta's question too, can someone's brother be a mediator in a case involving his or her sister? And that should be no. You can, but a mediator must be neutral, and they shouldn't be aligned or have an interest in the outcome. And so often we don't make recommendations. We don't tell people what to do. In most models of mediation, that's the principle, is that we don't make a recommendation. In some instances, we are allowed to do that with the consent, permission, and authority of the parties who hired us. An example of that, and here this happens in Chicago, where parties in a dispute often hire a retired judge to make a recommendation on how to resolve a dispute, because a judge has presumed neutrality from his or her prior experience sitting on the bench. Maybe they retired and now have a practice, a mediation practice or an arbitration practice outside of their court job. Sometimes mediators are asked for a recommendation because they have a special authority, they have vast experience, maybe they're seen as the epitome of neutrality, and so they're asked to suggest a solution, not to make a solution, but to suggest a solution. We call that evaluative mediation, as opposed to facilitative mediation. There's a big difference between the two. We don't, as mediators, evaluate and suggest without each party saying we should do that. And often we get that approval in writing. Why? Usually when a recommendation is made, somebody is going to assume it favors the other side. And we don't want to lose, as a mediator, our perception of neutrality or our evidence of neutrality by making a suggestion that one party feels favors the other side. And so we don't, as mediators, become active in trying to suggest a solution, but we can be active in trying to keep people talking. And that's often the role in community mediations. I see someone else has decided to share their screen. So we can become active in encouraging people to continue talking, encouraging people to continue sharing ideas, and encouraging more sessions. But we should never be an activist. We should be persistent in our work to keep people communicating. Anything else?
Thank you. Thank you very much, sir.
Sure.
Sir, good evening, sir. This is Kritika from Tamil Nadu. Sir, my question is, I have two questions. One, I still don't understand the exact scope of the community dispute resolution, sir. So my doubt is whether for a smaller problem we can easily apply the CDR process as you mentioned, but for a larger community problem like sir has mentioned about the citizenship issue which was going on in India. So how do we use this method for resolving the number one? And second one, Atna and Vatna formula in your practice, sir.
So in community disputes, we're not always looking for the solution. we're looking for the conversation. An example of that is I was doing work, I've been to a couple other countries, and you know, around the world, the issue of refugees and the travel and the displacement of people and their appearance in other countries, usually without permission of the receiving country, is a big problem. And so when the refugee issue was becoming very problematic in Europe, we were called to come to Greece to work on that issue as a community dispute problem, because the Greek nationals were against refugees that were coming from all around the world, from Africa, from Central Asia, lots of different places. We didn't, excuse me, we didn't go there to solve the refugee problem. We went there to have community conversations. And so we would invite members of the refugee community, members of the local government, other citizens, all the various stakeholders, to have a conversation about what it meant to be a refugee and what the refugees, why they were there, what they hoped to accomplish, whether they even wanted to be there or whether they were just on their way somewhere else and came to Greece because it was the easiest place. And so we did that starting in 2013, over a few years, but we never solved the problem. We helped people understand what it was meant, why these people were even there. And the Greeks found out that nobody really wanted to be in Greece. They came to Greece, as their stories were told, because Greece as an island has the easiest border to cross, right? And because there's all kinds of points of entry, and it was the closest way to get to Europe from Africa. And so when the Greek people realized that they were all on their way to another European country, many of them wanted to be in Germany, where there were job opportunities and different opportunities available to them and a larger population. Once the Greeks understood that that was the problem, and once the Greeks could then talk to members of the European Union about, you as the master organization of all of Europe have to help us with this problem, then the other borders opened up and other European countries took members of the refugee community to there. And you may remember back several years ago, each of the European, well, not all of them, but most of them agreed to take some people from Greece, and they were allowed to move from country to country, so that the Greek island itself, which only has 10.5 million people, that they didn't have to bear the burden of supporting 1 million refugees. And so we didn't reach a solution. We helped people understand the problem and gave information to the governmental organizations that could help solve a community problem. Okay?
Yes, sir. So, and my second question was about the use of BATNA and WATNA in your practical.
Sorry, I forgot. So BATNA and WATNA. BATNA is B-A-T-N-A, best alternative to a negotiated agreement. And WATNA is the worst alternative to a negotiated agreement. And those two terms come from the Harvard program on negotiation, which I mentioned at the beginning when we talked about negotiation briefly. And in negotiation preparation, if this was a full negotiation course, we would be talking about how you can prepare for a negotiation by considering what your alternatives are if you don't reach a settlement. And what we teach people to do, although the very modern view on BATNA and WATNA is don't use it, that it confuses most people, and that we should be thinking more about litigation interest risk analysis, or LIRA, L-I-R-A. That's another topic for another day, because I don't want to confuse everyone by introducing a new concept, but there's still great value in understanding what your alternatives are if you don't settle. And we as mediators often ask the parties in dispute a simple question that gets them to think about that. Well, Kritika, if you don't settle your case today and you have to go back to your court litigation what's the best thing that can happen to you in court? And it gets you to think about, well, if I'm the lawyer and I do the best job I can and all the evidence goes in perfectly and the judge likes the case and I get the best decision, I'm going to get a judgment for 10 lakh, whatever it may be. And then I would ask Kritika you the same question. I said, and so that's the best. So what happens if you go to court and you have just a crappy day, excuse me, but it's just a bad day. The witness messes up, the judge doesn't like the case and disagrees with you. What's the worst thing that can happen to you if you don't settle today? And you'll probably say, well, the worst thing is I get no award and maybe I have to pay the fees of the other party. And so we use BATNA and WATNA as mediators to reality check or to test whether or not achieving a settlement is better than those alternatives. And each side should do that in a dispute. We ask each party to consider their best and worst alternatives. And often that helps people get more realistic about a possible settlement, because when they've done a good analysis of that, and maybe we have them predict the legal fees that might be incurred in the future that a party might have to pay. And so we get them to think about all those risks that are attendant to continuing to litigate a dispute versus the value of resolving it in our mediation today. Okay?
Yes, sir. Thank you. Yes, thank you, sir.
Should we move on to, let's talk a bit about COVID, and we'll take a break again and make sure we get all your questions covered as we go along. And so we want to talk about COVID a bit because I think it's really a game changer, and we now are in many places. I think in your country and in my country here, you know, we have 50 states, and the state I'm in is basically hovering. We have a couple of neighborhoods, and I live in a neighborhood with some young people, and when we went back off of lockdown, the number of cases in my neighborhood went up. And so in my city of Chicago, state of Illinois, we're still in a phase 4, which means some of the restaurants are open with limited capacity. The stores are open with some lockdown restrictions. States like Florida, Texas have gone way up. California went way up, and so they're going back into lockdown. And so the travel bans and restrictions in my state, we banned people from coming in from 20 other states. Oh, maybe not 20. I think it's 15 or something now. It goes up a little bit every day based upon the data from each state. And so we had the complete lockdown. We came out of it, and right now we're going back into a lockdown. And so when we think about COVID as a game changer, we have to not only think about the way we were all being locked down in May, but because of the way this virus spreads and how easily it is spread, we look not only to lockdowns, but re-lockdowns or what happens again. And so we might have thought we came out of something, but we can have a phase 2 or a phase 3, and I really believe this is going to be going on for quite some time. And so we have to prepare ourselves for being subject to these lockdowns and restrictions for some time. Here, our court systems opened up in some limited way just recently, but they're very scaled back. The projects that are going on, we have still very challenging supply chain and logistical problems around the world about how we can ship things back and forth. We know in the middle of the pandemic in March and April, it was very difficult for people to comply with contracts. And so we were looking at defaults, tenants whose businesses were shut down, were not paying their rent, people who were supposed to be shipping goods to people around the world couldn't do that, and so their contracts went into default. So we really saw this giant game-changing impact on the global economies. And so as dispute professionals, we were all kind of gearing up as, what are we going to do? How are we going to help people resolve all these disputes? It really was a perfect storm. And it was being felt back in March and April by businesses and economies around the world. People started to come out of it, and they're opening up their businesses again. But there's still a number of disputes that exist from those original beginning of year or early spring lockdowns. And so people in our community, in the dispute resolution community, are now still working on disputes that involve claimed or real defaults from the impact of COVID-19. And so these were the challenges that we've seen, and maybe now we are going to continue seeing, or perhaps even some new disputes. How do we implement changes in, for example, a public works protocol? I advise some people in the construction industry, and we tried in the US to keep those projects going on, but they had to go on with different kinds of protocols. And they had to be, how do you social distance on a construction project where I have to hand you some material, right? If the government imposition was that you had to maintain a social distance and I have to hand you some wood, how can I be 6 feet away from you when, in order for me to safely hand you a 100-pound piece of wood, I have to be closer than that? And so we were called in to advise what kind of protocols have to be put in place to keep people within compliance. Perhaps that involved this kind of dialogue between people. We had to meet with the governmental agencies, contracting parties. Sometimes it was with general contractors and subcontractors. How do we get people working and still not cause COVID-19 spread on a job site? How do we continue our work and not have people claim defaults if they were just trying to get out of a contract? So we were called in almost as dispute management professionals, not dispute resolution professionals. Nobody wanted to just shut down a job unless we had to do it. Everybody wanted to comply. Everybody wanted to keep their employees safe. Sometimes it was the employees themselves who were demanding that their companies implement protocols. And so on many sites, and now that we've opened offices again, we are advising people. And all of you in the legal profession probably have been asked to do this already, or maybe will be asked to do it now, is how do we set up protocols for our clients to manage the new guidelines put in place by governments, or perhaps new guidelines put in place by the companies that we're being asked to deal with. And so in addition to protocols, we were asked to analyze contractual clauses. Some of them very clearly allowed for the cessation or stopping contracts to go ahead based upon the language in those contracts. Sometimes we were asked to review whether there was insurance available that might pay for these contractual defaults. You know, some of those clauses worked, some didn't. Sometimes we have finance agreements that we had to look at that allowed people to not pay the lending company because of these kinds of pandemics or force majeure provisions. Usually we were recommending people to not wait, but to establish lines of communication using online technology. After we reviewed contracts, let people know what was going to be an issue in the future, and ask people to get ahead of the dispute by saying, let's start a conversation about how are we going to manage this contract under COVID-19 restrictions. And so we recommended they establish early communication, keeping in mind that we would gear those early communication systems to the way our governments around the world said we needed to be behaving under COVID-19 restrictions. And sometimes we had to send what we would call a pre-action claim letter that would notify people that we are aware of a dispute. Maybe that invoked an arbitration clause, but we might suggest to them, instead of arbitration, why don't we hire a mediator now in advance of an arbitration notice, and see if we can come up with a solution that was temporary in nature until the government guidelines on managing COVID-19 restrictions changed. Because we knew everything was going to change, that the early restrictions were very severe. We didn't know how long they were going to last. We knew that each governmental entity could put a restriction that may be changed on June 1st, but always could be delayed by month or week by week, depending upon what it was. So communication was really our first line of activity, was to encourage clients to initiate communication. And how did we do that? We couldn't call meetings, right? So we used technology to do that. So we were recommending people to use Google Meet, Zoom, whatever, Teams, whatever systems were available out there, Skype, to start conversations, sometimes just between the parties, sometimes between the parties and counsel. And so those were the challenges that existed in the early part of this year. And in reality, they still exist today. There's, in my practice, there's still not a lot of people who are willing to meet face-to-face to have these conversations, no matter what country they're in. And so we were giving people the opportunity to start these conversations to talk about, can we renegotiate our contract so that it meets the interests of both parties to it, the buyer and the seller, the landlord and the tenant, the government and the contractor, whoever the parties are. All these contracts needed to be renegotiated somehow. So the people who had negotiation practices, or perhaps were negotiation consultants, found themselves quite busy trying to figure out a way to use some model of negotiation to renegotiate a contract so that we didn't have lingering claims out there. That we said there was a default, the default, was the result of a pandemic. Let's change the terms of our contract and use some other way of managing in the interim until we know that we're free to resume the terms of that contract. And so what happened was we used all kinds of online tools to do that. Oftentimes, clients in dispute began to take advice from dispute management practitioners, usually starting to take in advisors if they didn't have, for example, if litigation counsel was geared for court only, and that was their practice, and the court was closed, or we knew we couldn't get before a judge in any timely way. Clients, businesses around the world, and it could be small clients, it could be big clients, started taking advice from dispute management people to say, what are our options going to be? We know we have a default, we know we have a dispute. What would you do? What were you going to recommend to us? Because we know we don't have litigation available, we need an alternative. And so we learned that, and I spent a large part of my professional career in litigation in court, and so I'm not against it. I favor other things now, but we learned that the pandemic taught us one lesson across the globe, that pursuing litigation shouldn't be on the menu in the face of the pandemic. It's best to take it off or move it down that list of alternatives, because litigation is always an alternative available to solve a dispute. But often it went way down the list because it wasn't available. The courts were closed. There was no way to get into court to get a resolution. And that way up on the list was dispute management. with a focus on options such as renegotiation of contracts, mediation, what we call mediation arbitration models, or arbitration mediation models, or something that some companies like to use called neutral evaluation, hires somebody to make a recommendation to you to do something. All done online, all done in the only way available to us because of the pandemic, through what you and I are doing today. And so we saw lots of other opportunities. There were all kinds of people affected by this, not just these big companies, but the day workers, the people who were impacted by the dispute as well, who were out of work, employees, migrant communities who in some jurisdictions were servicing contracts, perhaps legally, perhaps illegally, who needed their rights represented or resolved too. And so I'm going to take a break now, and then we're going to talk about how we've used online mediation and online arbitration tools to do that. I have some specific examples I can show you on how we do it, but perhaps Q&A is the best way to manage some of these issues for us today anyway. But let's take a break for some more questions. We covered a lot of materials about, or a lot of thoughts about how COVID-19 impacted all of us, impacted legal systems, impacted governments, and created a lot of disputes. So let's take a break and do some Q&A.
If there are any questions from the participants, you can unmute yourself and ask your question. If there are any...
Hi, sir. Yes, sir. Sir, this is Shreya Mahajan. I just wanted to ask you one thing, that when you are talking about what are the changes that are brought in because of COVID-19 pandemic, right? We're also seeing there's too many domestic violence cases that are increasing, especially in India, right?
Yes.
And whenever it's a domestic violence case, we try to, in India, invoke mediation as an ADR. Don't you think, like, amidst COVID-19, at least, certain kind of online mechanism of mediation should be opened so that these domestic violence cases can at least be settled? Because the courts are shut at this point in time.
Yeah. This is...
So if that... Yes.
Go ahead. I'm sorry, I interrupted you. Go ahead.
No, that's okay, sir. So I just wanted to know the possibility and the plausibility of this.
I'm glad you brought this up, because in my remarks, I completely avoided this, and it's a very important issue, and we've seen this around the world, and when we're locked down, you know, we are with people many hours, and in family situations that may have been challenged already, the pandemic caused an increased level of conflict. And in those situations where violence was used to resolve problems, we found that the pandemic was a huge problem. And it was very hard to solve, because you couldn't go elsewhere, right? The time that you had away from your violent spouse was magnified and multiplied many times. And so in the dispute resolution field, we were very frustrated by how do we help people resolve family disputes where there is violence. In the past, we would use online dispute resolution so that we didn't bring mom and dad together, right? But now they already live together. So we really had this dilemma, is how do you help people when they're in the home where the violence occurs, and asking them to discuss the problem when they were in the same place. And it's a very important issue, and I can't tell you that we have a solution for that. Usually when we work with victims of domestic violence, the first thing we try to do is remove them from the situation where the violence occurs. And that what the pandemic did was put them in the place of violence. And so we thought about, and I'd be happy to hear your experience, Shreya, on how you manage that. we knew we needed people to participate in dispute resolution mechanisms, and it needed to be online because we couldn't do it anywhere else, but we couldn't find out how to separate them. Even in practices here in the States before the pandemic, we were really reluctant to mediate cases of domestic violence because we could be re-victimizing the victim of violence by having them come to our mediation room. So many times we used an online system so that we didn't bring the violent party back into the victims in the presence of the victim. So it's one of the most challenging things that goes on in dispute resolution already, multiplied 100 times by the pandemic. Agencies, whether there are centers where people can be taken, right? So there's domestic violence shelters available in some jurisdictions. Sometimes it's getting the victimized party, and perhaps if there's children, to another home where they're outside the presence of the violent person, and then conduct the mediations where they're not in the same place. Not the best solution, not always available, because we're moving people into pandemic-prone situations. We don't want people in group homes that can be re-victimized with a pandemic, but sometimes that's the better alternative.
Yeah, it is sort of a double victimization, at least in pandemic times, if at all we had to shift them to, group homes. So I am at least clear on this point. At least in India, we are having online filing and online court systems that are functional, but no online mediation processes, at least that have started.
Yeah.
And they should have been, provided that we are hearing about these domestic violence cases on a rise in India a lot during the pandemic.
Yeah, I think, that every time we have an obstacle, and my view about the world and life is that every obstacle creates an opportunity, and that perhaps this obstacle of the pandemic gives us an opportunity to advocate for online mediation of domestic violence cases, because there's a serious need for it. And so maybe we need, and I think it's true across India, that there's not a lot of uptake on mediation yet. We're hoping that we can move that along. And sometimes people may be more interested in moving to mediation now because the court systems aren't suitable for dispute resolution right now. So I'm hoping that we can see, I in the past have been able to come to India to talk about these things and work on these things a few times a year, but I don't know with the pandemic when I'll ever be on an airplane again. It's not a happy thought for me not to be able to resume my work in different countries, but we leave it up to all of you to start rowing the boat, and through efforts like these talks online and perhaps some other things we can do together to try to move this issue forward and teach people how they can use tools like this session or online mediation tools to help people in need. And those people certainly would include some of the most vulnerable, which are domestic violence victims, and sometimes requiring life-saving interventions that we need to make sure we don't lose track of those people as well.
Thank you, sir.
Better examples? Is anybody?
Sir,
yeah, go ahead.
I have a question, sir. Like in contracts, when you were mentioning that force majeure clause and all, but that should have been added at the time of entering of a contract. So this COVID-19 situation is something like that, which no one could foresee also. So if that is not added in the contract, can mediator help them to add? Or if not, then the only recourse which is available in India, I think, in case of contract is only frustration. Then frustration of contract happens. That's it. So
yeah, the legal. Yeah, go ahead. Yeah.
Yes, sir. That's it.
The legal principles you talked about are very true. That we analyze, as lawyers, we analyze those contracts. we're finding that the force majeure provisions really didn't offer a good excuse in most jurisdictions for the pandemic. The question you asked is, can a mediator help people change the contract? Of course we can, but only if they want to do it. We can't tell them the contract should say this, but they can renegotiate the contract. And we saw examples of that, where we might reach an agreement in mediation that the pandemic didn't excuse the performance of this, but we're going to remedy the situation with this solution, point A, B, and C. And we're going to modify the contract further to say, if the pandemic persists past January 1, 21, then we're going to interpret it this way and impose a new restriction. And maybe we're going to say forever a pandemic doesn't qualify as a force majeure going forward, or we'll agree that it does. So we can help people with a contract modification through a mediation session or a facilitation session or whatever. And that's smart business, right? I mean, you as lawyers, we would look at a situation and say, my God, we never thought something like this would happen. And so most contracts that I've seen don't talk about a pandemic. They talk about earthquakes, cyclones, you know, all of these giant natural disasters, but we never really thought about a health crisis. Some did, depending upon the origin of that, because there were countries where health crises did occur, but we never thought of a global health crisis that would affect global multinational contracts. And so now, if those of you who are practicing law, I think we all learned that when we draft contracts now, the word pandemic is going to be in there somewhere, right? I mean, we now have to, we have this awakening where good lawyering now is going to include what we learned from this, so that nobody looks at a contract in 2022 and says, sorry, we drafted this and we never included pandemic. It would probably be a legal malpractice now to draft contracts that don't mention the inability to perform due to a, call it pandemic or health crisis, however you lawyers want to define the terms of that. But what we learned from this pandemic is that we have to consider and draft provisions that cover COVID-19 situations. Because, you know, we're all here, we are all waiting for a vaccine or a cure. And I'm a pessimist about this, because we have, or maybe a realist is a better word. I try to be optimistic. As mediators, we're always optimistic, but a realist is a better word for that. We have to be a realistic person and say, maybe there's going to be a COVID-21. And so if we get past this one, we learn that out there's lots of things that happen that impact us in ways we don't anticipate. So let's do the best job in learning what we can from 19, and don't expect it's not going to happen in our lifetime. Or if it doesn't, it's going to happen in my kid's lifetime. And so as practitioners or as lawyers, we should be thinking about the next generation or two or three, and do the best job learning from this that we can. And guide our clients, guide our governments, guide our dispute resolution professionals. And maybe in India, it means have something like online dispute resolution available for domestic violence victims as well. And have domestic violence shelters available that have social distancing and pandemic protection systems available. In case something happens next year or the year after. But good question. I hope I answered it, that we don't impose that, but we have a really valuable role as mediators or as negotiation consultants, advising people to consider modifying a contract to include these things, because that's good practice now. It's good legal practice for all kinds of professionals. It's good business practice.
Thank you,
Yes,
sir.
Hello, sir.
So
This is Shyam Chakraborty. Sir, my question is, in this time of COVID-19, we have seen how community disputes also caused community spread. So how to bring all those communities together for effective solutions, as through online system it becomes really challenging or maybe impossible in many parts of the world to bring different communities together. So how to make ADR mechanisms effective in such cases related to community disputes in such a crucial time?
This is a good question. And so it brings us to a different topic, not today's topic, but what I call activism, right? And so when we see community disputes can be observed or we can participate in them in the form of a march or a protest or some kind of community activity. And we saw that happen. I certainly saw it here. And it really started with the Black Lives Matter protests after the George Floyd death, where in the middle of the pandemic and lockdowns, people were gathering and marching and perhaps not observing pandemic recommendations and guidelines to the best of their ability. And so as a community dispute mechanism, what do we do about that? The best we can do is to have people, or maybe not the best, but one thing we can do is to have people advocating simultaneously for protections against community spread. I'll share with you an example that I participated in. And that's an example of something quite positive. It wasn't a giant protest, but some of you may know, or you know, there's a few names I recognize. I do some work with the Afghan community with some efforts in Kabul and other places there. Sometime about a month ago, there were some Afghan refugees that were set on fire by some police in Iran, and 4 or 5 of them died and others were injured. And around the same time as the Black Lives Matter protests were going on, there was an effort to create a march in Washington to bring awareness to the Afghan refugee issue. And it really was a march perhaps against the Iran government. Turns out Iran doesn't have a presence in Washington, D.C., but there's a Afghan embassy there. And so people gathered there. And it wasn't a large group, but I went there. I have a young Afghan girl who's staying with me as a result of COVID. And so we decided to drive to Washington, D.C. And the reason I'm mentioning this is that protest was small. There was maybe 100 or 200 people there, but because of the COVID-19 restrictions, as part of their activism, they continually reminded all of us to not stand close, to wear a mask, to use gloves if you had them. If you had to touch, don't touch anybody. And if you had to touch something, don't touch your face. If you have to do something, come to us. And they had the sanitizer there. And so there was a bunch of speeches, but continuously. And each time somebody had the microphone, somebody came and sprayed the microphone and they cleaned it. And so you can think about safe protection mechanisms at the same time that you're recommending your activist protest. Easy to do in the situation I was in, hard to do in larger protest movements. But I think as an activist, it's wise to combine both, because you then gain credibility in the community by having a safe protest movement. We didn't see a lot of that around the US with the larger protests that you all saw online. And that was unfortunate because I think it could have created a view of protesting during a pandemic that lent a lot of credibility to the movement leaders and the protesters themselves. We now are seeing in the US protests that are anti-mask protests. And that's, there are people who believe that wearing a mask takes away our freedom. And in the US, we value our personal freedom quite highly. And we value that higher than spreading the pandemic. And so we now see, in the last week or so, I don't know if you've seen it online much, but we have people who are activists against rules and regulations regulating the spread of the pandemic. I'm not sure I answered your specific question. I'm just giving you some guidance. If there's a specific question, just come back. Shyam, I think it was Shyam who asked that. Tell me if I missed your point.
No, sir, it is clear now.
Good.
Thank you, sir.
Yeah, sure. Anyone else?
So this is Kritika again from Tamil Nadu. Sir, I would like to, sir, am I audible?
Yes, yes.
Yes, sir. Sir, actually, I would like to add one more challenge to the list of challenges provided by you. And this challenge is very much specifically to the developing countries like India. We actually have the challenge of proper digital infrastructure, sir. So, sir kept on talking about the online dispute resolution, but developing countries like India, where we actually lack proper digital infrastructure. So, this is a very big challenge to the implementation part of ADR.
Exactly. Thanks for mentioning that. And this is a real challenge. And then we had some fears. The next slide I was going to talk about was related to Zoom. And I know Zoom was banned in India for a while when there was the Zoom bombing and all that. And that was an infrastructure issue as well, about security issues that interfere with managing legal disputes online. But the very fact, and it relates a lot to the domestic violence issue, is do we have the capacity in homes to bring internet there to do an online dispute resolution, or do we have to bring them to some kind of center? And in developing countries, because of my travels there, I'm aware of the infrastructure issues that are present, and that's usually the requirement. And we work hard to figure out how to work around that. One of the things in maybe not pure mediations that I do, but we found that Facebook seemed to have connectivity positives that were better than Zoom or some of these other online things. And so we tried to search around for using other devices. And maybe not a video session, but maybe a WhatsApp session, because we had WhatsApp groups available. Facebook is developing Facebook rooms. There was another app that linked with a Facebook group that we tried at some point in time to do some sessions. And we have to be aware of digital infrastructure problems when we design our systems to make sure we don't set up a mechanism that excludes people or makes it very difficult for them to connect. Ideally, when we work our way through COVID-19, we're going to figure out how to have infrastructure locales that are available to people who are in dire straits, and we can get them somewhere. That's very hard to do in India, especially in the more remote areas. But I think our challenge, excuse me, our challenge as dispute resolution professionals going forward is to think about these infrastructure issues as well, and try to think about how we can design systems to make dispute resolution available to as many people as we can, or at least figure out how to get somebody who's safe to a place. For example, you know, if we can get someone to a center that's reasonably close to their home that doesn't have digital access, we may need to put those kinds of systems in place. But it's a huge problem, and not just in India, but as you said, in any developing countries.
Yes, thank you, sir.
Sure. Anything else?
Yeah, good evening, sir. This is Dr. Devanshu Srivastav from Jagran Lake City University, Bhopal. And hi, sir. How are you?
Good, good. Nice to see you.
Same here, sir. And my only question was in because I will take a clue from what you just answered regarding the disputes in the courts and the way forward for the ODR system. So what would be your suggestion, or if there are certain ideas that we can implement it at grassroots level of the universities, where the law students themselves can learn out of this COVID thing and or the such pandemics if they occur in future as well, and they can be future ready for the system to be taken to be online or to the ODR system. Your take on that, please.
Yeah, I think that this is a unique opportunity for the law colleges and law students. Why? You know what I mean by digital divide. There are some people that are closer to my age than yours who are very digitally challenged. That when I had to do a training for one of the international institutes to teach highly seasoned mediators and arbitrators how to work online. And they were basically told the pandemic put them out of business. And because they didn't know how to use Zoom or any tool, how to do an online mediation. And that's one example. And some of them are really brilliant people, but they didn't know how to do anything digitally. In arbitration and mediation, it's a face-to-face tool up until now. You at universities and students are uniquely situated that you're very used to the technology. And so you can take this opportunity and develop, because maybe your infrastructure is better, maybe it's not. I've been at different universities around India, and at first I thought it was going to be easy for me to get online, and I realized that usually it's not unless I'm in the library, I think. But in any event, this is a unique opportunity to set up online dispute resolution centers or hubs. And using the brilliance of the students and the faculty to teach this, and maybe even teach the professionals, and have them come in when things are better, have them come in and learn side by side, or mask by mask, however we want to do it, or even online like we're doing now, is use it as a hub to teach the professionals. What I've learned about teaching professionals is we're all quite proud. You know, and we don't want to admit our mistakes. And so when I worked online teaching professionals, usually I would get a call after the session and say, can you have a private session? Can you teach me this? Because they didn't want to admit in the group, they didn't have a clue of where the buttons are, or how to do this or how to do that. And if you're able to use this as a way to teach someone how to do an online mediation, the rest of my session, and I think it's clear we're not going to have time to do it, but I have some demonstrations on using, I prefer Zoom, and I know that's a challenge in India. Zoom for mediation, because it has breakout rooms, has a lot of security features. I have some demonstrations on how to use it in arbitration, even taking testimony from people. And I can assure all of you on the call, there's lots of technology available to use online mechanisms to do dispute resolution online, whether it's a mediation or an arbitration, or whether it's to teach people how to do that. And so let's look at, for all of you on the call, as this as an opportunity, perhaps to improve your locale, and maybe that's the city you're in, maybe it's just your university, maybe it's the lawyers in your locale, and maybe it's even the professors. You know, we had to learn how to move to online teaching, and I've seen examples of it that are quite poor, and so we all have to learn, not just to get through 19, but perhaps in the future we have to learn how to work digitally better. It's not fair to students to be bored all the time. We can't expect someone to listen for 90 minutes. That's why I designed these so that we have Q&A along the way, because it's impossible to watch someone speak for too long. And so we can use this opportunity. If I was there in India, I would be thinking about how to do some reach out to the local legal community. What are your needs in the time of the pandemic? What can we as an educational institution provide to professionals? And not that you're going to provide it for free, perhaps it's a revenue source for the university to do something like this, to bring people online to teach them, but perhaps it becomes a course, online mediation for legal professionals. And use the professors at your universities, use the students as coaches, and it helps the students as well because they're all networking, they're all looking for jobs. So to have some students present with the legal professionals is a wonderful opportunity for them to be thinking about internships and careers. And I think there's ways in the law school institutions for us to use this predicament as an opportunity to bring people together, even if it's digital, even if it's online. And it takes a little bit of thought to design these, to design them well, but I think you have to reach out to your legal communities. And I know that in what I've heard from the people like me who are now learning to work online in both mediation and arbitration, some say, I don't want to do it. I hire somebody to do the technology. So they'll hire a student who knows how to do this. And maybe they're present for the mediation and they just say, I want to go to room A with Dr. Srivastava. And so put me there. And then put me in this room, or set me up with another screen so I can see the transcript while I'm doing it. And so there's opportunities for employment for young people who are technologically savvy. But you have to find that. You have to make that opportunity known. There are a lot of people who do what I do who don't want to try to manage 2 or 3 screens. In arbitrations, we are now saying you need 4 screens. You know, you need one for this, one for the testimony, one for the transcript, and another to communicate with the rest of your team. And I want to focus on my job. I don't want to focus on technology. So I think the law schools are a great resource. That there are people doing it already. In the US, technology, and in some countries in Europe, technology companies that are now advertising will manage your arbitration for you. And they assign a person to your case and you're there. And I've done webinars and they say, if you have a problem, message Priya. You know, she'll be there if you have any issues. She's side by side in some other place. And so think about that as universities, as creating opportunities to improve your stature in the legal profession, network with professionals, maybe even make some money for the university. Yeah.
Thank you so much, sir. That was really great inputs, and we can definitely try things on that. Thank you so much.
Yeah. Any other questions?
Sir, I'm Anbarasi from Tamil Nadu, India. Yeah, good day. Good evening, sir.
Good.
Sir, I have a question relating to the confidentiality and secrecy of proceedings, sir. In case of court proceedings, we have enough confidentiality, adequate confidentiality and secrecy of proceedings. But in case of ADR, and now, as you rightly pointed out about ODR, online dispute resolution, how is the reliability of the confidentiality and secrecy of proceedings safeguarded? Is the legislations on ADR very powerful on right to privacy issues relating to this, sir?
Yeah, confidentiality is really one of the hallmarks or one of the very important things we have to think of in ADR, especially in the mediation and arbitration segments of it. So we know that in mediation, I'll discuss mediation and arbitration. So we know that in mediation, the process is confidential. There's high levels of confidentiality. When we work online, we worry about that. But what we do is we take the parties and we have them sign a confidentiality agreement. We do that even when we work in person. When we moved online, And I've been working online long before the pandemic. And so, for the past several years, I've taught people how to use online mediation and that. So I've been aware of this for a while. And it wasn't until the pandemic that people who weren't used to being online got worried about it. And there's always some concern about confidentiality, because if I have an online mediation, I can usually see how many people signed in, right? And so if I know I'm supposed to have 2 parties and 2 lawyers signing in, and I all of a sudden see, like right now, I can see there's 126 people in our room. It dropped down to 125, went back to 126. When I'm doing a mediation, I can see how many participants are signed in, and I can lock my room. And so I know I've created a confidential space for my session. The question then becomes, do you have someone else in your room, right? I can see that you're logged in by one device, but I don't know if you have 10 people in your room or you're just one. And so we ask people to identify if there's any other people in the room. And we place a lot of trust in the process. So we have them make some affirmations. We don't tell them to swear to tell the truth, you're the only one in the room, because that's really a bit intrusive for the mediation process itself. But we talk about confidentiality. We ask people to commit to not having others in the room, and we ask for people to commit to not record the session. Some platforms allow you to block the recording. I can see now that this session is being recorded, and that's fine. Everybody knows it's being recorded. In Zoom, for example, a platform I use, I can block anybody else from recording it, or at least I think I can. And when I trained people to do that, I trained them that don't believe that's true, because I can use another app to record the session. So don't think people aren't recording it. Talk to them about it and tell them that we don't want it recorded. And so in mediation, that's how we manage it. Arbitration is a bit more challenging because there's lots of other people. There's lots of other people that are entitled to participate. Many times in a complex arbitration, there's 8, 10, 12 people on each side, where there's teams that are of counsel, teams from the client. And so it's much more difficult to manage the confidentiality. In arbitration, the hardest thing is to manage the confidentiality of documents. And so we usually recommend to people that they use a separate confidential server for documents, that we don't use the Zoom platform itself to exchange documents. And that's one of the reasons for that other screen, is that we're using a firewall protected document server that's accessible to the parties and to the tribunal to do that. And it's, with technology, it's very, I'm not going to say easy, because I don't, I'm not saying anything is easy anymore. It's available. And if we plan our arbitration session well, we can protect someone else getting at our confidential documents. We can make sure that people don't attend our session by using a private room and locking the room and putting firewall devices in place. But confidentiality in arbitration is always been an issue. We often have taught members of panels or tribunals or arbitrators themselves, you don't use Google. You don't exchange documents. You don't sign in. You need a VPN. You need a private server. You're not going to look at your confidential documents sitting in a cafe logging in to a free Wi-Fi, because some of the cases we work on are big. For example, imagine one of you take Tata or some arbitration involving one of the big companies, or maybe a publicly traded company, and that if the decision is made, perhaps the value of the securities. For example, if I'm working on a big pharma case, take Pfizer or something like that, and if there's a decision made that affects the value of the stock, people could hack my website because they know I'm working on that case, and if they see a draft of a decision, they can buy or sell stock based upon what they think the outcome is going to be. And so if we work on a case that involves the markets, we are doubly, triply, quadruply cautious about protecting drafts of documents or any documents we see from anybody. And so it's a very important issue to manage confidentiality. Security is really, cybersecurity issues are a master layer above confidentiality. We have to make sure that the systems we are using are in place. Many of the tribunals themselves, ICC, AAA, the CPR, everybody, the FINRA organization, which are securities cases that I work on, we don't share documents. They're only done through the portal. And the portal has multiple layers of security. So we don't take documents by email from clients. We only take them from the portal. We can always download them and then have to put our own measures in place. But I think you raised an excellent point that if we're an arbitrator or a mediator, we have to make sure we're doing that. If we're counsel in a sophisticated, serious case, we have to make sure as well that we're abiding by principles that protect the interest of our clients, and that we don't get ourselves in a predicament because we're too lenient with using online mechanisms that don't have cybersecurity protocols in place around them.
Thank you, sir.
Makes sense? Everybody got that? Be cautious. Be cautious, especially in arbitration.
Thank you. Thank you.
So I think we're scheduled to end now. I'm happy to stay on a bit. I have some other slides, and let me just talk you through a couple things. So what I wanted to make sure that everybody was aware of is that when we move online with our matters, that we can feel quite comfortable with it, right? If I'm a young lawyer in a law firm, I realize that I can manage my digital technology quite well. But always think about the client. Is that if you're going to bring a client into a mediation or an arbitration, you might be ready, but you have to take some practice sessions with your client and make sure the client team is ready. And so we recommend that you add some practice sessions to get the client team familiar with the online mechanism. And that might just be in a mediation, it might be just how the session is going to work. In an arbitration, if there's going to be client testimony taken online, and the client's going to have to look at documents or photos or some kind of exhibits, we recommend that you walk your client through those practice sessions. You would have done that anyway, but you would have had the client come into your office and you would have walked them through testimony. And so don't forget that online, and add extra time to do that, because it's not easy for a client for the first time to work with digital documents and being able to see that. You may actually have to counsel them to use two screens, one the testimony screen and one the document screen. And so because you're ready, don't assume the case is ready. Always practice with clients, teach clients, and get them comfortable, because you want a client who's giving testimony as comfortable as possible. When we're the dispute resolution professional, if I'm the mediator, I'm going to schedule some practice sessions as well. It might just be one with each side separately to make sure they're comfortable with whatever tool I'm using. And in an arbitration, I may ask for that. The tribunal itself may schedule a 1-hour practice session with everybody involved to show them the technology. And so I see a lot of young faces online because we're ready. Use your knowledge to teach the people that you're going to have in your session. Then you can begin to move online, and you'll find that if you've done that, you have a level of comfort and your clients have a level of comfort in you. And it's really very good trust building tools for clients when they know you're managing something that's new to them and you're concerned about their ability to manage that technology as well. So assume that you're going to have some practice sessions, explain the process about moving online, move online. One of the things that you might find resistance for the client is that maybe they don't want to move online. that they want a face-to-face, and you might be encouraging them to move online because that dispute might have to be delayed a year in order for them to have a face-to-face resolution. One of the things that we knew as well is that a lot of us thought, well, if we wait a month or 2 or 3, we're going to get back to normal. And for lawyers in law firms, we can't survive by waiting. We need the hours, we need the billing, we need the revenue. So we have to work with our clients to teach them that we have to find this new normal. We have to be able to move online for dispute resolution, even client meetings, even advisory meetings. We have to be willing to move online. So you have to encourage your clients to use online tools to conduct their law advisory sessions as well. It's good revenue for the firm. It's good for clients to get used to it. And the transition to moving to an online mediation or an online arbitration is easier when they're used to seeing you online with client advisory meetings and team advisory meetings for the clients. The other thing that I can tell you about is the tools that different people are using these days are numerous. For my practice, we found that Zoom was one of the better opportunities because it had these breakout rooms that we could use that are quite important in mediation, to have private sessions using a private meeting room, and it was quite easy to move from one room to the other. We found that quite valuable in arbitration as well, because we could have a breakout room that was just for the tribunal, so 3 of us would meet in the tribunal room. We would have a lawyer's room if the lawyers from both sides wanted to meet privately outside the presence of their clients. We had a lawyer room, and we could also have a claimant room and a respondent room, or even more of them if they wanted some other kind of team rooms. And so when you think about online dispute resolution, look for a product that has available to you the tools that you need to match how your case is going to proceed. And then practice with those tools, or get advice from someone who can guide you in choosing those kinds of tools. With that, I'll take some more questions. I can stay on longer. I don't think we're going to get any great value. I can show you a demonstration of a mediation session or a demonstration of an arbitration session, but I think you can find many of those online. If not, someone can send me an email and I can share with you some links that will let you see the video at your leisure, rather than taking time for the group, because I think our Q&A session is probably, for these sessions that the university designed, are more valuable than just watching 5 or 7 minutes of a video. Any other questions?
Sir, this is Anvarasi again, sir, from Tamil Nadu, India. Sir, it's a plain question, simple question. Relating to the alternate dispute resolution, how far it is successful globally when you compare it with the court proceedings, sir? For 100%, how much percent are you able to judge now? Yeah, that's really the alternate dispute resolution when compared to the court proceedings.
So here's what we talk about in answer to that question. Across the globe, the average still is around 75% of all disputes that go to mediation get resolved in mediation. We know that 100% of cases that go to court get resolved by court because there's a decision, right? But in the court of first impression, that's not always the resolution. There's an appeal at the first level and sometimes an appeal for the second level. But of the 75% that go to mediation, 99.9% of those there's satisfaction with, there's compliance. And so we think that's a very persuasive argument for clients to take their dispute to some mechanism that creates a better result for them. And the better result is they came up with the solution, not a judge. And they came up with a solution that's going to be resolved. And usually the result of a mediation is the relationship between the disputants is often preserved. Usually in court, the first thing we tell our clients, right, is don't talk to the other side. And so usually we participate in destroying that relationship by trying to ensure some level of control over the litigation. And so I think internationally we're going to see, especially in the light of COVID, global contracts being renegotiated by dispute mechanism. Global mediations or cross-border mediations have always been a possibility. We always had a problem with enforceability. If we did a cross-border mediation, in many jurisdictions, India in particular, they were worried about the enforceability of a mediation dispute. Last August, there was a tool developed, and it'll become an enforceable device in September of this year, called the UNCITRAL Singapore Convention on Mediation, that makes to the signing and ratifying countries that, much like the New York Convention created enforceability with arbitration, the Singapore Convention is going to create enforceability by participating countries for mediation settlement agreements. And so we believe, and that was just signed, I happened to have been able to be in Singapore at the signing ceremony last August, and we now have some 57 signing countries, and sufficient countries have ratified it that it will become enforceable as each country ratifies it, starting in September of this year. So we believe that cross-border or global mediation will become an even more popular tool, even amplified by the presence of the COVID epidemic or pandemic that has created a mechanism for doing mediation of cross-border disputes that might be more efficient than international arbitration disputes.
Thank you, sir. Thank you.
Sure. Anybody else have a thought or a question? Now, you guys are doing this all week, right? Are we, we're at our time. I see some people, we're losing some people because they have other commitments. I'm happy to answer a couple more questions before we end. I see somebody just asked in the chat box, Shilpa, can you please explain what norms we can use for simulation exercises with regard to ADR? I presume we're talking about teaching dispute resolution to students and perhaps even doing that online. We find that more in mediation than in arbitration, that simulations are the most valuable tool. And I've been using, even in the pandemic, simulations online. I actually find that if we think about how to design that, using breakout rooms and private sessions like that, we can create a simulation online. And that's quite realistic. And so what I do is I share, it's really the most valuable tool. If you're teaching online mediation or you're teaching mediation online, it's the most valuable way to give students the experience of being in a mediation or mediating. And so I highly recommend it. I think it's the only way to do it. I do it this way. I create a scenario or what we call a role play, so a fact pattern. And then we have some confidential facts for the party A that are different from party B. And I distribute those to certain of the students in the class in advance. And so they keep them confidential. And then I can assign that to a team or to an individual. And then if I'm doing a team, I have them meet privately and I visit with them in a breakout room and work through it with them. And then we bring them into to a session together and they conduct a mediation using the confidential facts. I use that for different elements of negotiation strategy as well. and walk them through a negotiation leading up to the mediation. And so I think simulations are proven to be the most valuable teaching advice for teaching the tools of mediation. Students in particular enjoy it. It's much different. Usually we do some lecture. So we tell them, then we show them a bit, and then they practice it. And so if we divide our sessions into those three components and make sure they get the chance to practice it in the group, and I try to involve as many of the students as we can. Usually the first time I do a simulation, there's a reluctance, right? We're all a bit shy. But once they see their peers participating in a role play or a simulation, by the end of the day, the week, whatever I'm working on, most students gravitate towards participating in it because they see that they can learn a lot. And then when we do the simulation, we build in as the last element of that a feedback session. And in my feedback sessions, I give feedback, but I ask all the other participants in the class, the other students, to give feedback as well, because then I can learn whether they understand it. Because I can learn if their feedback is off, if they're giving feedback that doesn't match the content that I instructed in, I can make that correction at the time as well. So it's a double way of learning. And so use your simulations.
Thank you so much, sir. We'll now conclude this, conclude the session. I would like to extend my heartfelt gratitude on behalf of the organizers, Iswar Saran PG College, University of Allahabad, and Droit Penale Group, a unit of Arjun Gulati Memorial Society. It was really an interacting, informative, and enriching session, sir. Thank you so much for sparing your precious time for us. And I know the participants will really benefit from this. Thank you so much, sir.
Good. Thank you all for attending, and all the best to all of you. Be safe, and we get through this together.